It's 9 a.m. on Wednesday, March the 5th. The House Criminal Justice Subcommittee is now in session. If everyone would please take the roll. Mr. Clerk, take the roll, please.
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you, sir. Members, do we have any personal orders before we begin today? I certainly do. I have with me today as a guest, Chief Vess from the Chattanooga Housing Authority Police Department. Thank you for being with us. And I also have the world famous Abigail Kidd, accompanied by her father, Tommy Lee. And they're in the crowd with us today. So thank y'all for being with us. Tommy Lee is our circuit court clerk in Lawrence County. Does a fantastic job down there. Everybody knows him. Everybody knows Abigail. And then they happen to know her daddy, Tommy Lee. So they never meet a stranger. All right. We'll go to our Sergeant of Arms, Mr. Tyler Muniz, for the weekly words of wisdom.
Good morning, everybody. I hope y'all had a great Mardi Gras yesterday and happy first day of Lent. Laissez-les bon temps rouler. Today's words of wisdom come to you from Aristotle. Happiness is the meaning and purpose of life, the whole aim and the end of human existence. Y'all have a great day.
Thank you very much. I didn't know you spoke foreign languages. All right, members. Item number 1, House Bill 1093 will be rolled 1 week. Item 7, House Bill 314 will be rolled 1 week. Item number 9, House Bill 1353 will be rolled 1 week. Item 27, House Bill 706 will be rolled 1 week. Item number 39, House Bill 836 will be rolled 2 weeks. And item 46, House Bill 721 will be rolled 1 week. That brings us up to item number 2, House Bill 113 by Representative Gillespie.
Motion.
All right, you are recognized, Representative. Welcome back. Do you have any amendments? We're on House Bill 113.
Sorry. Thank you, Mr. Chairman. No, sir, I do not believe we have any amendments.
All right, you're recognized on the bill.
Thank you so much, Mr. Chairman and committee. What this is doing, a couple of years ago, we passed, the General Assembly passed a law allowing for certain people to have access to testing strips for fentanyl and other types of narcotics testing. And there was a sunset on that. And what this is doing is just removing the sunset. With that, I welcome any questions.
Thank you for that. Members, are there any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 113 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 113 will move on to full judiciary. Representative, you are on the calendar, I believe, at number 23. House Bill 33 by Representative Gillespie. You are recognized.
Thank you so much, Mr. Chairman and committee. What this bill does is it involves issues of bail across the state, and specifically back home. We're dealing with a lot of issues involving defendants that have been accused of some pretty violent crimes that, for whatever reason, are being released on their own recognizance, even if they have prior history and other things in their records that may go against this. And so what this would do it would still allow for those people to be released on their own recognizance, but it would require the judge of any judge, not just the judge of record. So this would include a magistrate to list their written findings for the record at the time it takes place if they decide to release that person on their own recognizance. And with that, I welcome any questions.
Thank you for that explanation. Any questions for the sponsor, Representative Powell?
Thank you. Just to clarify, so basically, they just have to list the reasons. Okay, and that's simply it. They can still do it. They just have to document that.
That is correct, and it's my intent for that to happen at the time when the decision is being made.
And one last question: is it permissive? Do they have to list a reason?
Thank you. Yes, that is my intention. I believe it says in here. It says the magistrate or such official must include the bail order written findings for each factor listed. So it's my intent for that to be required.
Okay, thank you.
Chairman Farmer.
Thank you, Mr. Chair, and thank you, sponsor, for bringing this bill. It looks like, as I read it, looks like it's only going to apply to serious crimes. Looks like C felonies and up. So especially aggravated assaults, attempted murder, things like that. So appreciate you bringing the bill.
Any other questions, comments for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 33 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 33 will move on to full judiciary. Item 24, House Bill 38 by Representative Gillespie. You are recognized. No amendments.
Oh, yes. Sorry. Thank you, Mr. Chairman and committee. This is a bill that this committee passed last year, and it was changed on the floor last year. But this is my Parental Accountability Act. And what it is going to do, and right now this is all permissive, and we're basically just adding some parameters and requiring it. So after the third offense, after a juvenile has been adjudicated for their third offense, this would put a civil fine on the parent or legal guardian. And if they cannot afford that fine, then community service would be an option. The genesis behind this legislation is most people know what's going on in their household, especially if it's a young child. If they show up, if they're under the age of 16, they have a vehicle in their driveway, they have a lot of cash, a lot of nice objects. Somebody knows something that's going on. And again, this would only take place after the third time that a juvenile court has found you delinquent. And with that, I welcome any questions.
Thank you for that explanation. Members, do we have questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're now voting to send House Bill 38 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 2 nays.
The ayes prevail. House Bill 38 will move on to full judiciary.
Thank you so much.
Is that all you got?
Believe so.
Have a good day.
Okay.
Item number 3, House Bill 854 by Leader Lamberth. We will roll him 3 spaces. Item number 4, House Bill 1315. I guess by Leader Lamberth as well. We'll roll him 3 spaces again. Item number 5, House Bill 1328 by the chairman himself, Representative Chairman Halsey. All right, you're recognized.
Okay. Thank you, Mr. Chairman. Thank you, committee. Not too awfully long ago, we started a SAVIN program that was a reporting system for victims who wanted and needed to keep up with the status of who the offender or what the offender was doing, if they were getting ready to be released, if they were out on bond or got out on bond, or if they were released from sentence. We expanded that program, that reporting program, that applied to pretrial and through the court system. And we started it as a pilot program last year. It's been very successful, and folks like it. And sheriff's departments have honed it down to a science, and it follows an offender through the court system. Pretrial hearings, bail hearings, trial and sentencing. All that information can be gleaned through this new system that was on a pilot program. This bill this pilot, by the way, sunsets in June of this year. So all this bill does is say we're going to keep it on and go on with it and hope for the same success.
Well, thank you for that explanation. Members, do we have any questions for the sponsor? I do have a question. So with this program, a victim, if I'm hearing you correctly, and for everyone else, which I know the answer, but a victim will be able to track the progress of that case through the court system. Is that right?
All the way from front to end, yes. It also lines up, I didn't say this, but it lines up, if we ever pass Marcy's Law, it puts us in the right posture for that too.
Because that would be a constitutional amendment if it passes that would require victim notification, and this is a mechanism that will make that happen.
There you go.
Yes, sir. Fantastic. Anyone else? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1328 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
And the ayes prevail. House Bill 1328 moves on to full judiciary.
Thank you, Mr. Chairman. Thank you, committee.
Yes, sir. Thank you. All right, we're back to item number 3, House Bill 854. We will roll 3 more spaces. And then item number 4, House Bill 1315 by Lamberth will roll how many spaces? 3 spaces. Item 6, House Bill 1025 by Chairman Russell. You are recognized.
Thank you, Mr. Chairman, committee. Last year, this General Assembly defined bullying and cyberbullying. If this bill passes into law, this will suspend a driver's license for a minor for 1 year if it's adjudicated in court and they're found guilty.
Thank you for that explanation. Members, are there any questions for the sponsor? Representative Powell.
I guess a question for the sponsor, and I'm obviously against cyberbullying in every form, but how do you believe or feel that as a sponsor of this, taking away that juvenile's driver's license is going to, I guess, get them back on the right track? Because what I'm concerned about is when someone doesn't have the ability to drive and, go to work or do other productive things, then they find themselves obviously being, I guess, more willing to do other nefarious things. So that's my concern with the bill. I'm just curious if you could address that.
Thank you. There is a mechanism so that their license will not be suspended and simply just not to bully another person. I think this is a deterrent. A lot of kids nowadays wants to get their license when they get 16, and it's an incentive not to bully other people.
And I appreciate that, and I'm all for that. I just think if you're trying to get, our juveniles to be productive members of our society, then taking away their license is going to let them have even more idle time and be even less productive. And that's kind of my concern with the bill. So thank you, but I appreciate what you're trying to do.
Thank you.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1025 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 2 nays.
The ayes prevail. House Bill 1025 moves on to full judiciary. Chairman Farmer.
Hey, thank you, Mr. Chair. And I know I'm out of order. Members, we have leadership Bedford County here today, even though that is not in my district. That's Speaker Marsh's district, but evidently Congress was full, and so they decided to come and spend some time with us today. So I just wanted everyone to make them welcome. Thank you so much for being here.
Hear, hear.
All right, we'll go to item number 8, House Bill 761 by the Chair Lady Littleton. You're recognized.
Thank you, Mr. Chairman. House Bill 761 fixes the definition of harmful to minors in the Protect Tennessee Minors Act. In short, this is a cleanup bill. Simply put, this change strengthens the Protect Tennessee Minors Act to best withstand legal challenges and will save the state years of potential litigation, while in no way decreases the practical coverage of the law.
Thank you for that explanation. Members, we have any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 761 on to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 2 present not voting.
The ayes prevail. House Bill 761 moves on to full judiciary. Members, we'll go back in the calendar to item number 3, House Bill 854 by Leader Lamberth.
Motion.
Second.
You're recognized.
Thank you, Mr. Chair, members of the committee. There's an amendment coded 004431 that makes the bill.
Second.
All right, you're recognized on the amendment. The amendment does make the bill. Any objection to adding this amendment on to 854? Seeing none, we're voting to add amendment code 4431 on the House Bill 854. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt on House Bill 854 as amended. You're recognized.
Thank you, Mr. Chairman. This comes from one of our local judges, and it just allows them to take into account reliable hearsay when setting a bond. Primarily what we're talking about here are criminal histories. And so the criminal history is an NCIC. It is not something that every judge has the ability to be able to run on their own. So if an officer is testifying from a criminal history, they're able to take that into account when setting the bond.
Any questions for the sponsor? Representative Powell.
Just a question for the sponsor. Could you speak to a little bit more clearly the hearsay evidence and what reliable hearsay evidence would be?
Thank you, Mr. Chairman. And again, the best example that I have, and really the reason for the bill, is for criminal histories. I mean, so that's something right now where there's usually an objection on a hearsay where it's an out of court statement that's offered for the proof of the matter asserted, and it's a reliable hearsay. I mean, it's what the officer sees on that criminal history. Obviously, the defendant is there and participating as counsel, has an opportunity to refute anything that is brought forward, but it allows the judge to be able to hear that evidence at least.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 854 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays, 1 present not voting.
The ayes prevail. House Bill 854 as amended will move on to full judiciary. Item number 4, House Bill 1315 by Leader Lamberth. You are recognized. There's Amendment Code 3652. Do you wish to proceed with that amendment?
Yes, sir, Mr. Chairman. It does not make the bill, but it does delete and substitute in an important section.
All right. You're recognized on the amendment.
Mr. Chairman, this just deals with noncompliance of the ignition interlock process. If a judge reviews this after they're already past their revocation period for their driver's license, and the individual has only violated potentially for calibration, monitor, inspection of the device, then the judge has to make specific findings to that, and they still can relieve an individual from the ignition interlock device, but they're going to have to attach the it's a calibration report, basically, that is from the Department of Safety or the ignition interlock company, just to show that that judge has actually seen that report before they made a decision.
Thank you for your explanation. Any questions on the amendment? Seeing none, we're voting to attach Amendment Code 3652 on the House Bill 1315. Those in favor say aye. Those opposed? The ayes prevail. You adopt. We're on House Bill 1315 as amended. You're recognized.
Of the bill basically just gives some flexibility for the ignition interlock process. We've built this up over the years. It tries to make sure that if someone is convicted of a DUI and there was alcohol involved, they have an ignition interlock device, a breathalyzer in their vehicle to make sure that they can't start it while under the influence. It's a very successful program, but we probably got a little too strict in some regards. Life gets in the way. An ice storm hit a year or so ago, and folks couldn't get into their calibration. So it's not really fair to extend somebody if literally it's impossible to get there. So just gives a little more flexibility on the timing of when they have to be calibrated, and doesn't take away from the program.
Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting to send House Bill 1315 as amended on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 1315 as amended. We'll move on to full judiciary. We'll go to item number 10, House Bill 587 by Representative Scarborough. You are recognized. Is there any amendments with this bill?
No, sir.
You're recognized.
Thank you, Mr. Chairman. Interrelated patterns of criminal activity and conspiracy to constitute racketeering committed by criminal groups and gangs, organizations should be targeted for enforcement and enhanced penalties. As provided by the current state Racketeer Influenced and Corrupt Organization Act of 1989, better known as the RICO Act. 2 years ago, the General Assembly wisely added to that act a various list of crimes. This bill would add 3 more crucial offenses to the list: organized retail crime, possession of or employment of a firearm during the commission of a dangerous felony, and carjacking. This bill will give law enforcement district attorneys the tools they need to disrupt, dismantle, and incapacitate criminal gang organizations and conspiracies across Tennessee. With that, sir, I'll pass on for questions.
Thank you for that explanation. First on my list is Leader Lamberth.
Thank you, Mr. Chairman, and to our esteemed colleague who just recently joined us a few months ago as a freshman, I am curious, is this your first bill in this committee?
No, sir.
Yes, sir.
Well, Mr. Chairman, he didn't ask to be recognized by the chair. Did you give him a nod or anything?
I think I threw my gaze at him. I don't know if that would.
Okay. Well, I am just impressed, Mr. Chairman, that a freshman got you to sign on to one of his bills, and I thought maybe it was his first one, and that's why he did it, to just try to help him get through. But it sounded like a good bill to me. Good luck.
I would remind the freshman legislator that we are on the record while we're in here, and I do not recall calling his name for a bill in this committee as of yet. Yes, sir. Go ahead.
I could have been mistaken, sir, but But I thought I brought a safety bill here, but it could have been a different committee.
Leader Lambert.
Mr. Chairman, I make a motion to roll those 3 spaces. Let the young man evaluate whether or not he's been in your committee previously.
Second.
All right, without objection, roll House Bill 587, 3 spaces.
Members, we have, now we're on item 11, House Bill 573 by Chairman Doggett. Sir, you have a motion and a second, and I'm not seeing any amendments here, so it looks like you're properly recognized.
Thank you very, very much, Mr. Chairman. House Bill 573, we are lowering the felony amount of fentanyl from 150 grams to 50 grams, which is a violation of this, would be a Class A felony.
Thank you, Mr. Chair. And I do have on the list requested to testify. I have some folks from the Tennessee Attorney General's Conference. Is that something that we wanted? Did you want to go to session and do that, or just okay? Members, do we have any questions for? Excuse me.
Yes, sir. We do have.
Okay, fair enough. Then we can do that. Members, want to go ahead and do that now? Okay, without objection, we're going to go out of session here from Steve Crump, Mike Donovan, and potentially Courtney Lynch. And here, if you would, just have a seat there. The red lights on your mic should come on. I'll ask the secretary, she just turn both mics on, leave them on for you guys. And you have 3 minutes to piece to give us your opinions here, and then we'll have unlimited questions from there.
Thank you very much. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference, and I'm joined by Mike Donovan, who is the Deputy Director for Legal Services and Policy. We appreciate you all listening to this bill. Clearly, the situation involving fentanyl in this state and frankly all around the country is one of the most devastating public safety issues that this country has ever faced. As we look around, there's probably not anybody that you know in your community who has not either seen somebody whose life has been completely destroyed by a fentanyl addiction, or they have died from that. There are very few people that you can talk to who this has not touched. And as such, what this bill would do is to lower the A felony threshold from the current 150 grams down to 50 grams. And to give you a sense of what that is, 50 grams will still kill 25,000 Tennesseans. That's how dangerous this substance is. It's also how little it takes to end a life. And what we're seeing, and you all have heard this, and I'm not going to take too much time with this. People will think that they have gone and bought something else. They have bought a hydrocodone, or they have bought a Xanax, or they bought something else. It's actually something that's been pressed in a homemade pill press with aspirin and then fentanyl. And we will typically see rashes of death where you will have what's called a hot run, where there's more than a lethal amount. So we would ask you to support this bill and ask you to make Tennessee safer with it. Thank you.
Thanks, sir. And I have, thank you for that explanation. I have Representative Powell. You have any questions?
Just a question, and I appreciate this bill. Obviously, fentanyl is a major problem throughout Tennessee. I've seen a lot of deaths in my community. I know a hospital in my district is overrun with overdoses. If someone was found to have this fentanyl that had been blended or laced in with other product, would you be able to then, if you seized it, it can be blended in and you're able to trace those 50 milligrams? It wouldn't have to just be in a pure form, correct?
You're recognized, sir.
Sorry, I was looking at the wrong. Apologize, Chair. I was looking at the wrong chairman. That's old habits die hard. I apologize, Chairman Farmer. Typically, no. Typically, we would not be able to separate that out. So if somebody had, say, 10,000 fentanyl pills, that would be charged under a different section of the code, because we would have to test each individual pill to determine how is it, and we simply can't do that. So what would happen, this would be where it is in its collected form, in a singular form.
Mr. Chairman, I can also add to that. Representative Powell, I think what you may be referring to and thinking about is a bill that was passed last year regarding a delivery of any combination of fentanyl and another drug that causes an overdose death, where we move that penalty into the second-degree murder statute. So we can do it for purposes of overdose, any combination of fentanyl with another substance, but not for possession or delivery under this A felony statute. It's got to be pure.
And if I could, Mr. Chairman, one more question. Okay, thanks. How many more people do you think this would allow us to prosecute that would meet this threshold? I mean, are you seeing a number where it's a lot of people have 100, and this is lower to 50 would capture those? Go ahead.
I don't know that we know exactly how many we would capture. Certainly we could, if we ran, we could probably look and see from our testing at the Tennessee Bureau of Investigation how many of the cases fell between this number and the current 150. I don't know how many that would be. And then also a lot of that would depend upon how was it collected? Was it part of, if you find somebody like that, do they end up being prosecuted? Do we end up being able to, do they go to the federal system? Do they end up, the United States attorney end up taking that case? Does it end up being part of a bigger investigation that may be multi-jurisdictional? So it's hard to say how many of those would actually be charged here, but certainly for the ones that we do charge here, we believe this penalty would be an effective deterrent.
Representative Powell, you good?
I was just going to add, Mr. Chairman and Representative, I think it's also what many of our drug task force officers are seeing on highway interdiction in the way that it's packaged and trafficked in bulk. And the district attorneys just believe that a Class B felony, where it currently sits at 50 grams, is not sufficient to deter or punish the lethality of that amount.
Very good. And thank you for that. Members, anyone else? Chairman Doggett, do you have anything?
Yes, sir. Thank you, Mr. Chairman. You said something, 50 grams would kill 25,000 people. Current law is 150 grams. That would take out my entire district, my constituency, with 150 grams of fentanyl. How big would 150 grams of fentanyl be if you were to show with your hands?
The end of your thumb, probably. Probably the end of your thumb. We interdicted on the northern border with Canada 47 pounds roughly of fentanyl. That's enough to kill 9.5 million Americans. That gives you a sense of it. There are anecdotal reports of law enforcement officers who have gone in and made arrests. They've come out with what they thought was dust on their uniform. It was actually fentanyl powder, and they've brushed it off, and transdermally, they've overdosed and had to be hospitalized and treated for that. It's an incredibly dangerous substance and incredibly addictive as well.
Good. Members, anyone else? Chair Lady Littleton, do you have anything? All right, members, anything else for our guests? Thank you, gentlemen.
Thank you.
All right, without objection, members, we're ready to go back in session. Looks like we are. All right, we're back in session. We're back on the bill. Any questions for Chairman Doggett? Chair Lady Littleton, you're recognized.
I just want to thank the sponsor for bringing this bill. And I read reports from time to time about a child gets the parents fentanyl just by touching it and the child dies, or they have to Narcan it. But actually, there was one parent that touched the baby, and the baby actually passed away. So this is a good bill, and the stuff is deadly for sure. Thank you.
Thank you. Representative Salinas, you're recognized. It's coming.
There we go. Well, I just wanted to echo what you were saying in the sense that we have a real big problem here. And I've worked in drug discovery, and just to kind of put things into perspective, a therapeutic index that is good for a safe drug, we try to hit over 1,000 therapeutic index. For fentanyl, the therapeutic index is 2. Meaning that it is very easy to overdose. It is very easy to be outside of the therapeutic index and be in a lot of trouble. And we've seen this in our community. And I plan on voting for this, but if we continue to ignore the root cause of mental health care, of people having access to it, to the care that they need to take care of whatever it is that they're dealing with that is driving them to seek out drugs, we will not make a difference. We can bring this number down to 1 gram, and it will not save lives if we continue to ignore the care that people in our community need.
Thank you for that. Members, anyone else for Chairman Doggett on the bill? Seeing none, we ready to vote? Any opposed to the question? All right, all those in favor, vote aye. Opposed, vote no. Everyone voted? Anybody want to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
Very good. Members, Chairman Doggett, looks like House Bill 573 moves on to full judiciary.
Thank you.
And that brings us to item 12, House Bill 578,
Motion.
Second.
also by Chairman Doggett. Sir, you have a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. House Bill 578. It's already an offense to possess a firearm with the intent to go armed during the commission of or the attempt to commit a dangerous felony. It's also an offense to employ a firearm during the commission of or the flight or escape from the commission of or the flight or the escape from the attempt to commit a dangerous felony. And what this legislation will do is it'll expand the list of dangerous felonies and add 17 felonies to this list. With that, I'm ready for questions.
Members, you've heard the explanation. Any questions for Chairman Doggett regarding House Bill 578? Any questions? Seeing none, we ready to vote? Any objection to the question? All right, all those in favor, vote aye. Opposed, vote no. Every member voted. Anybody want to change the vote? All right, Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 2 present not voting.
Very good. Congratulations, Chairman Doggett. House Bill 578 is moving to full judiciary. That brings us to item 13, also by Chairman Doggett. That's House Bill 579, members.
Motion.
Okay. All right, if we back up just for a moment, that would bring us to an item that has been rolled 3 spaces. If we could, if we could roll that 1 more space, Representative Scarborough, and we'll take up item 13, 2 spaces, 2 spaces, members. Move item 2 spaces. Without objection. All right. Now we're on item 13, House Bill 579 by Chairman Doggett.
Second.
So you got a motion second. I'm not seeing any amendments. You're probably recognized.
Thank you, Mr. Chairman. House Bill 579. It's currently a lawful possession of a firearm with a prior conviction of a crime of violence or attempt to commit a crime of violence is a B felony. This bill adds robbery to the definition of crime of violence. It's currently not on the list, although aggravated robbery and especially aggravated robbery are. And so that's what we're adding this in to simply fill that gap in the definition that is currently written.
Thank you for the explanation, sir. Members, any questions for Chairman Doggett? Members, any questions on the bill? Representative Powell, you're recognized.
Just a question. Will this increase the criminal penalties at all by adding this?
Chairman Doggett.
It does add that into as a crime of violence. From my understanding, this does not increase anything other than what it is now. It's just adding that into the definition.
Representative Powell.
Just a follow-up question and separate to that, but so if someone was committing a robbery and they had a gun on them but did not pull the gun or whatever, and they were found to have a gun, then it would be considered an aggravated offense. Is that correct under the bill?
Mr. Chairman.
No, sir, but I do have someone here to testify that can probably answer that question for you.
Yeah. Okay. Members, do we want to go out of session here? Testimony? Anybody oppose? Seeing none. All right, Mr. Crump, Mr. Donovan. All right, Representative Powell, do you have, did you want to ask the question to It's,
Just wanted my follow-up question to that. So if someone had committed a robbery and they did have a gun on them, on their person, but did not pull the gun or show the gun, and they were found, let's say they were, how is that adjudicated, or how does that process work out to where this now becomes a violent act?
So Representative Mike Donovan, Deputy Executive Director, Tennessee District Attorney's General Conference. So Representative, actually this bill is seeking to amend the statute that involves possession of a firearm by a convicted felon. There are certain categories into which those offenses fall. If you are a prior convicted felon and you have a prior crime of violence conviction, the penalty for possessing a firearm is a Class B felony. If you have a prior drug felony, it's a Class C felony. And if you have any other felony that's not drug or violent, it's an E felony. The list of offenses in the definition of crime of violence left out robbery, which we believe is in fact a crime of violence. That's what this bill is seeking to do. To your question, aggravated robbery is committing a robbery with a deadly weapon, like a firearm. But you would have to use, display, brandish, or employ that weapon to commit an aggravated robbery, which is a Class B felony. If you merely committed a robbery while in possession of a firearm but did not use, brandish, point, or employ that, and yet you were still a convicted felon after you passed this bill, then that would be a crime of violence, and you would be charged with a Class B felony for being a felon in possession of a firearm.
okay, thanks. Representative Powell, did that answer your question?
It did.
Members, do we have any other questions while we have our guests up here? All right. Thank you, gentlemen. All right, members, object, we'll go back in session. Leader Lambert, you recognized.
Question on the bill.
Question has been called. Members, any objection to the question? Seeing none. Members, looks like we're voting to send House Bill 579 to full judiciary. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member like to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays, 1 present not voting.
Very good. Looks like House Bill's moving on. House Bill 579 is moving on to full judiciary. Congratulations. That brings us to item 14, members. House Bill 583, also by Chairman Doggett.
Motion.
Second. Sir, it looks like you got a motion and a second on that bill. I'm looking at Amendment 003623. Is that something you'd like to move forward with?
Yes, sir. It does make the bill.
It makes the bill. And you've got a motion and a second. Members, we want to go ahead and put that amendment on the bill. Any objection? All right, seeing none. All those in favor of adopting House Amendment 003623 to House Bill 583, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Chairman Doggett, you recognize.
Thank you, Mr. Chairman and committee. This deals around forensic interviews that are conducted in our child advocacy centers. Under current law, funding for child advocacy centers requires that there be a memorandum of understanding and working protocol signed by all county municipal law enforcement agencies within the geographical area that is served by the center. This is a funding requirement, has nothing to do with the admissibility of the forensic interview as evidence in a prosecution for child abuse or child sexual abuse. However, some courts across the state have ruled that if the forensic interview is inadmissible because the Child Advocacy Center did not have a MOU. And so for funding does not have the signature by every law enforcement agency, many of which are small or do not investigate child abuse cases. And there's numerous examples of those, airport police, university police, railroad, and so forth. Also, each time the department head and the chief or the sheriff changes, the MOU must also be recirculated amongst those agencies for signatures. So this is a very technical thing here, and so the admission of signatures related to funding does not affect the ultimate reliability of the forensic interviews and should not deny their admissibility as evidence in these important cases. And so what the amendment does that rewrote the bill, it doesn't take away from the original intent of the bill, but it separates the funding requirements from admissibility requirements. It requires that as so long as the accredited Child Advocacy Center has signed an MOU and working protocol with the Department of Children's Services and any district attorney general, the forensic interview is otherwise admissible under the statutory structure and rules of evidence Also providing that the signature of any district attorney general, this amendment allows the CAC in one judicial district to perform courtesy forensic interviews for cases in other judicial districts where the CAC or qualified forensic interviewer may not be readily equipped or available. And it also adds in there, it makes clear that the CAC, that forensic interviewer can testify in court, and not necessarily the child victim, but the victim must be present.
Thank you, Mr. Chairman, for that explanation. Members, do we have any questions for Chairman Doggett on this bill? Seeing none, any objection to the question? All right, seeing none. Members, looks like we're going to be voting to send House Bill 583 as amended to full judiciary. All those in favor vote aye. Opposed, vote no. Has everyone voted? Anybody want to change the vote? All right, Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
Very good. House Bill 583 as amended moves to full judiciary.
Thank you all very much. We're back on item number 10. Leader Lamberth.
Mr. Chairman, I think item number 10 was by Representative Scarborough, and we have a crack team of researchers here on this committee, and they have researched the hundreds of bills that have come through your committee thus far and been through here. And it does appear that he briefly had a bill that was on the calendar, but he took it off notice. And Mr. Chairman, I'll leave it up to you on a judge's ruling on whether or not that counts, but it sure doesn't seem like it counts as your first bill to me.
Just looking across the committee, I would say that they concur with your thoughts, but
Thank you, Mr. Chairman. Again, I wish the freshman luck with his first bill in the Criminal Justice Subcommittee.
well, thank you. Item number 10, House Bill 587 by the Representative Scarborough. You are recognized.
Thank you, Mr. Chairman, and the leader's correct. I reviewed my own bills, and he is correct. This is my first one. My apologies, Leader. Again, this actually adds 3 additional offenses to the RICO Act of 1989. Organized retail crime, possession of employment of firearm during commission of a dangerous felony, and carjacking. This bill, again, will help law enforcement district attorneys provide the tools they need to disrupt, dismantle, and incapacitate criminal gang organizations and conspiracies across Tennessee. With that, Mr. Chairman, I'll take any questions you have.
Sorry about that. I missed that entire presentation. Could you start over? Yes, I'm sorry. You're recognized.
Thank you, Mr. Chairman. Again, 2 years ago, the General Assembly wisely amended the act to add some various multiple offenses, but with this bill will actually add 3 more offenses: organized retail crime, possession of employment of firearm during commission of a dangerous felony, and carjacking. With that, Mr. Chairman, I'll take any questions.
Thank you for that explanation. Leader Lambert.
Thank you, Mr. Chairman. And Mr. Chairman, with each recitation of the description of the bill, it does appear to become briefer. And by the time it gets to Chairman Farmer's committee, it might even be a couple of sentences, but I thought he did a really good job. And I can see why you signed on to the bill now. It seems to be a very good bill. And his apology to the committee seemed heartfelt, and it was deeply appreciated, I think, by all of us.
I'll agree with that. Chairman Russell.
Thank you, Mr. Chairman. I was looking up the definition of racketeering. It says a pattern of illegal activities that often involve organized crime. And I was thinking we might be able to show an example of that by getting a pattern of rows. And if I'd like to make a motion to roll this 2 spaces.
Second.
Without objection, we'll roll House Bill 587 2 spaces. Item 15, House Bill 751 by the Chairman Faison will be rolled 3 spaces. Item 16, House Bill 1177 by Chairman Williams will roll 1 week. That brings us back to item number 10, House Bill 587 by Representative Scarborough. Leader Lamberth.
Move previous question.
Previous question's been called. Any objection? Seeing none, we're voting to send House Bill 587 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 587 moves on to full judiciary. Congratulations. Members, let's go to item number 18, House Bill 473 by Chairman Crawford. You are recognized, sir.
Thank you, Mr. Chairman. Thank you, Vice Chairman and committee members and guests. This bill that I am presenting today, House Bill 473, deals with DNA samples. We currently take DNA samples if somebody's been arrested, convicted, and then they're serving time in jail. We had a problem back in my area, Northeast Tennessee, in a city that I partially represent in Kingsport. We had a gentleman that was killed. He was murdered, premeditated. His wife got raped, and it was just a really bad deal. And at that time, this was back in 1997, we just didn't have the technology and the improvements that we have now in DNA samples. So this gentleman later on in life, he probably thought he got by this and was never going to be convicted on it or whatever, just living a happy life, doing what he wanted to do and still breaking the law in certain areas. And he got arrested again. They got the DNA sample and compared it to the DNA that they had collected back in 1997, and he was convicted after 27 years. So what this bill does is addresses things like that will help us solve some cold cases that are not just in my district, but your district. When a person is arrested and indicted for a felony, the LEA must take a DNA sample before they can be released, or must be a condition of the bond. And what this bill will do, it will require, and I hope I say this term correctly, I'm not a medical physician, but I did stay at a Hotel 6 last night. But they take a buccal swab, a sample that goes into the record. It will be there, and this will be when they are arrested. It will go on file. They have to follow all the laws and regulations that TBI has in place for that. If they are released, then the DNA sample is also a condition of their released. Once that happens, TBI has to be notified. If the case ends up being dismissed or the defendant is acquitted, TBI must destroy all records of the sample. That is law. So they will keep, if you're acquitted or you take a lower plea or whatever, then they have to destroy this. DNA would be used, hopefully with the technology and stuff that we have nowadays, to solve a lot of unsolved cases. So that's what this bill does. It takes DNA when the person is arrested of a felony or whatever, and they go into the jail, and we have it up front and not after the conviction and those type of things. I stand for any question, Mr. Chairman.
All right, members, do we have any questions? Representative Salinas.
Hi. So earlier this session, we passed a bill that would criminalize local elected officials if they vote on a sanctuary city bill or policy. If a local state official or a local official were to do that and they get arrested, their DNA would go into CODIS.
I didn't hear exactly what you said. If they were arrested for what now?
For passing a sanctuary city bill, their DNA, then they were to be arrested, which we passed. Their DNA would be swabbed, and their DNA would go into CODIS.
Mr. Chairman, I'm not familiar with what the penalty is for that, but if it's not, at the level of a felony, then they would not be.
We voted on an E-class felony.
Then they possibly could be swabbed, yes.
Okay, thank you.
Any other questions for the sponsor? I do have a question.
Yes, sir.
It was brought up earlier this week, and if you've got someone locally that is charged with a felony today, they would be swabbed under this bill. 6 months from now, of course, they're still going through the court process and everything else, waiting for their day in court, but they commit another felony. Would they be swabbed again additionally, or would that one swab from the previous offense be sufficient?
At this particular time, they would be swabbed again according to the way the law is written. I hope to address that later on. I've talked to the attorney generals and several of my district attorneys, my district attorney and others. And I think what we're going to do is come up with some wording that would say if they have previous been swabbed and that sample is still good, that they would not have to be swabbed again, because there's no use for our locals having to pay for it again.
Sure. Thank you. Leader Lamberth?
Thank you, Mr. Chairman. Chairman, thank you. And there was a lady that testified at a hearing in Chairman Farmer's committee just a few weeks ago, and there was a bunch of us that signed on this bill, due in large part to her testimony. I mean, her sharing her personal tragic history and her heroic push forward to advocate for bills of this type throughout the nation. She's a survivor, and she's a phenomenally strong person. And I think all of us were impressed with her testimony. So we have been impressed with your presentation on the bill, but even more so by her testimony. So I'm certainly honored to be a co-sponsor of this bill. I think most of us are. And it's just been a long time coming on this issue. It's time. So thank you for bringing the bill.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Leader, for your kind words. But with the technology, the way it has advanced, this just seems like it's the right thing to do. And it's not about me. It's not about you guys. This is about fellow Tennesseans that have been wronged, that hopefully this will make things right for them.
Any other questions for our sponsor, Chairman Farmer?
Thank you, Mr. Chair. I'm a previous question.
All right, previous question has been called. Any objection? Seeing none, we're voting to send House Bill 473 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 nay, 1 present not voting.
The ayes prevail. House Bill 473 moves on to full criminal.
Thank you, Mr. Chairman. Thank you, committee.
Yes, sir. Thank you. We'll go back to item 15, House Bill 751 by Chairman Faison. You're recognized. There's an amendment code 4507.
Yes, sir.
All right. You recognize the amendment. The amendment make the
That
bill?
amendment's yours,
That
Mr.
is my
Chairman. I'll
amendment.
let you talk about that.
Well, yes, sir. All we did is we took your language and added, I think, 4 words. And those words are a fentanyl derivative or analog is what I want to make sure we got that right. A fentanyl derivative or analog.
Mr. Chairman, I take that as a friendly amendment to this bill.
All right. Without objection, we'll vote to attach amendment code.
Just on the amendment.
Oh, yes.
Yeah.
You recognize.
Just a question. I don't know with the amendment, but it says any amount. I know, and maybe this is done to the sponsor once we add this, but I'd just like clarification on that.
Yes, the amendment adds those 4 words. The rest of it was his original language. He can address that then. Any other questions on the amendment? We're voting to attach Amendment Code 4507 on the House Bill 751. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt on House Bill 751 as amended.
Thank you, Mr. Chair. Committee, it's certainly good to be with each one of you this morning. I don't know if you've paid attention to our drug issue in Tennessee. We are, this is embarrassing for us to admit, but we're in the top 5 in America. I think currently right now, top 3 in America for overdoses. And I've spoken with our local DAs. I've spoken with our Opioid Abatement Council and asked them things that we can do. One of the things that my DA and the Opioid Abatement Council all looked at is the notion that we have parents or adults who have the analogs and all the stuff that goes into making fentanyl and high-powered drugs that are killing people in front of children. And so this bill, I'm simply just trying to increase the penalty with that amendment of having the stuff, the analogs or the fentanyl in front of a child. It's a Class C felony, 1 to 6 years, $3,000 fine to knowingly possess fentanyl or its derivatives around a child, putting them in imminent danger. And then if it's a child 8 years or younger, it would be a Class B felony, 8 to 30 years and up to $25,000 fine to knowingly have that around a child. I think this could potentially help. I don't know if we're going to get it fixed, but I don't want us to be in the bottom 5 of overdoses. And I feel like this is one area the DAs agreed with me that we could do something.
Thank you for that explanation. Representative Powell.
Thank you. And I guess I just kind of want to get this on the record. And I fully appreciate what you're trying to do here. Say you have someone that has a subscribed for fentanyl and some sort of medication that they're taking for cancer, let's say, and the child somehow got a hold of that pill bottle and took a pill or something. I know you say here in the law it would be unlawfully possessing, but in that circumstance, with it being prescribed, would that person then would they not be captured under this, or how would that play out?
Thank you, Mr. Chair. Representative Powell, that's an excellent question. I think it's worth having a discussion about the intent of this bill and what I believe the legislation of this bill, the actual text of the bill is for people who knowingly have something illegally. If you have a prescription, this bill doesn't apply to you. That's my understanding of this bill.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 751 as amended on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 1 present not voting.
The ayes prevail. House Bill 751 as amended will move on to full judiciary. Item number 17, House Bill 547 by Leader Cochran. You are recognized. There are no amendments.
Thank you, Mr. Chairman. So House Bill 547, it creates a public safety fund for the District Attorney General's Conference that is similar to the pre-existing Public Defenders Fund. It establishes a charge of $12.50 to provide additional support services for promoting public safety, address local needs. Long story short, this is a fund that used to be supported by cases regarding the writing of bad checks. Nobody writes checks anymore. Oh, well, maybe a couple of us do. Sorry. And every now and then me. Sorry, most people, not all. And so that fund has dried up. And so the Public Defenders Conference, public defenders already have this fee. This would just be a fee that parallels that to support district attorneys. I'll yield any questions.
Leader Lamberth.
Move previous question.
Previous question is called. Any objection? Seeing none, we're voting to send House Bill 547 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 547 moves on to full judiciary.
Thank you, committee, and I apologize for offending any check writers this morning. Thank you.
Brings up item number 19, House Bill 1225 by Chairman Lafferty. You are recognized.
Thank you, Mr. Chairman, and thank you, committee. This bill, as many of you already know, probably, or should, I think would already know, there are several restrictions that we require of convicted sex offenders after they are released back into the public. Some of those reporting mechanisms, one that I noticed was not in there. And I say I noticed it. I'm trying to take credit for a constituent back home. Let's admit it. She's a lot smarter than I am. She found this not being included when it came to our religious institutions. And she reached out to me and asked me if I could maybe get that added to the list of requirements, reporting requirements that the released offenders are supposed to make. That's the origin of the bill. I would like to put that into code, but it is my understanding at this time that there are some other issues that might need to be looked at. So I appreciate you taking a minute to listen to me. And if I could, I'd like to roll this for 1 week.
All right, thank you. Without objection, we'll roll House Bill 1225 1 week.
Thank you, Chairman. Thank you, committee.
Yes, sir. Thank you. Item House Bill, we're going to item 22, House Bill 962. Chairman Hawk. You're recognized.
Thank you, Chairman, members. House Bill 962 comes to us at request of many local governments who are having challenges with CBD and hemp stores in their districts. This particular piece of legislation, upon agreement with whomever will oversee the hemp and CBD laws in the state of Tennessee, either it be the Department of Ag now or in the future, if Leader Lambert's bill goes forward with the ABC, that in conjunction with either one of those entities, a local government will be able to set up a CBD/hemp board that would govern much like and help enforce laws and rules on hemp and CBD, much like a beer board would be set up. It takes the exact language and really crafts the language exactly as our beer boards are set up. It is a piece of permissive legislation. And I'll read from one of the first lines. The requirements of this part are in addition to all other requirements of this chapter and must not be construed to prohibit or restrict the ability of the department to enforce the chapter. Our state departments are still in charge. This would just be a partnership with a local CBD/hemp board. That's what the bill does. Working with sponsor of other legislation, I think we can maybe even improve on this in the future. But in this committee, the posture of the bill, I certainly ask for affirmative vote.
Thank you for that explanation. First on my list is Representative Powell.
Thank you. I appreciate the sponsor bringing this bill. I've actually spoken to some of my council members in the city I represent, Nashville, and issue becomes because unfortunately sometimes there is sort of a lack of regulation. And I know the last bill was just rolled dealing with kind of zoning issues and where things can operate. You know, there are certain limitations as to where you can say serve beer, alcohol, within certain proximity to churches. But we've had an instance where a couple of these have opened up really close to schools. They've opened up close to churches and other places. So I think having the ability, if cities want to do this or counties, and have a new organization set up to kind of put in some guardrails and regulations, I think is a good idea. So I support your bill.
Thank you.
Leader Lambert.
Thank you, and thank you for bringing this legislation. And I know from a technical standpoint, the legalese may have to be changed a little bit just to fit with some of the other bills moving. But I joined with my friend from Davidson County and what he said. In Davidson County, there are over 550 either approved or pending permits for vape or hemp stores right now. And even in a city of the size of Nashville, it just seems excessive. And at some point will actually hurt the market where many of those folks will wind up going out of business because there's just too many of this particular one type of store. But at the end of the day, that should be a decision for Nashville to make. And so that's what this bill allows for them to do. So if they want 550 plus, then they could certainly do that. If they wanted fewer than that, that would be an option. So appreciate you bringing the bill. I think it fills a niche that was not previously there.
Chairman Farmer.
Thank you, Mr. Chairman. Move to previous question.
Previous questions called. Any objections? Seeing none, we are voting to send House Bill 962 on to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote, please.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 962 moves on to full judiciary.
Thank you,
Thank
Chairman
you.
members.
Item number 20, House Bill 835 by Chairman Kiesling. Leader Lambert.
Thank you, Mr. Chairman. I consulted with Chairman Kiesling on this, and I would make a motion. And again, I consulted with him before he left. Make a motion to roll this to last calendar.
Second.
All right. The motion is to roll House Bill 835 to last calendar. Item 21, House Bill 884 by Chairman Todd. You are recognized.
Thank you, Mr. Chairman. Many of you are aware of a significant Supreme Court win that the state of Tennessee had last week when the Supreme Court basically confirmed the constitutionality of a bill that a law that we passed a couple of years ago. It was House Bill 9 at the time, and I was honored to carry that in the House, and it greatly restricted obscene shows in front of kids. But we found through this process, there's a loophole. The original law, as it was written decades ago, established 1,000-foot boundary around businesses that is their primary business, of strip shows and things like that, other adult type venues. But it did not establish that same boundary. It didn't specify that that same boundary would apply to a show had it be if it were had at a civic center beside a church. So this bill closes that loophole and says even the performance has to be within those or outside of those boundaries of that 1,000-foot radius. And so I'd be glad to take any questions.
Thank you for the explanation. We have on the list Representative Powell.
Thank you. If I could ask a few questions on this, I know you're discussing facilities, but could you elaborate on what you mean by facilities? Because it seems like we're greatly expanding beyond just places that do this regularly to just places that might have a irregular, like once a year show. Is that correct?
That is correct. Any building, any facility, no matter what their purpose is throughout the year, right now in the law, they can have a one-off strip show if they want to. For example, I have a civic center in my district, and we've got a lot of complaints from citizens over this, that at that civic center, we have a lot of fundraisers for nonprofits. We have symphony events, just tons of things. But now we have an adult-only show there once a year. And folks have really gotten upset because they read the law and it says it's got to be 1,000 feet. But if you really get into the language of it, it restricts it to a building where that's their predominant business. And so those 1,000-foot restrictions don't really apply to a one-off event. And folks are pretty upset over that.
And I guess a follow-up question here with this bill, didn't the Supreme Court address the issue of standing by the plaintiff in the case that was in Memphis dealing with this issue?
All I know is they upheld the lower court ruling, and my understanding of the interpretation from our AG, which put out some press releases about it, was that our law has been upheld. So I'm not sure of all the particulars of that case, but certainly right now I don't know of any other challenges. I do know that when that case was first discussed in Memphis, the ACLU refused to take it because they said it was constitutional. We were confident it was when we wrote it. So this just helps close another loophole that we've discovered in this process.
Yeah, and I guess last, just a comment, I voted against the initial bill. I still think it is greatly oversteps. I support the LGBTQ community, and certainly think that drag shows have a place, very rich history in our country, and think they should continue to have a rich place in our state. And I feel like, and I understand there maybe have been a bad actor or two, but to have any facility that would host one of these events, to now have to basically register and become some sort of adult entertainment type facility, I think is a gross overreach. And again, how far is this going to go? Is there going to be a concert held where somebody interprets it as a drag show, and now that facility is going to be shut down or held liable under this? So I think it's just a broad overstep, but I appreciate you answering my questions.
I will say in response to that, this legislation nor the previous legislation mentions drag shows at all. It's not in there. This literally deals with obscene things that are in front of children. This is protecting minors from obscenity. That's all this is about.
Thank you, Representative Salinas.
Thank you. Do you consider drag shows obscene?
I can't comment on that because I've never seen one. I don't attend those.
Oh, well, you can come to my district and we can go to the drag show, so you can have an opinion. In my library in Memphis, we have Story Hour. So would they fall under this, since we're expanding that definition of locations?
In my opinion, based on what little I know about those type things, it would not, because this doesn't deal with drag. As I said, it's not mentioned in here at all, how anybody dresses. This is literally about, and it's very spelled out in the law today, of what obscenity is. So any kind of sexualized behavior, any kind of nudity, those type things are spelled out in the law today. And we're just saying, if you're going to do that, it's 18 and up, that's already in the law. But now this bill just says that the location you have that obscenity has to be outside the boundaries that are already specified in the obscenity law we have today for facilities that do that as their normal business.
Okay, and from an administrative side of things, how would this be enforced?
Currently, law enforcement does monitor this, and they would enforce it just like they do any other law in the books.
We have so many things that we ask law enforcement to do. I think adding this is not a good use of taxpayer money.
I would argue this is not adding anything. This is simply completing a little loophole that's in the law already.
Next on my list is Leader Lamberth.
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 884 to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 2 nays.
The ayes prevail. House Bill 884 moves on to full judiciary.
Thank you, Committee.
Next item on our list is item number 25, House Bill 821 by Representative Slater. You're recognized, sir.
Thank you, Chairman. This bill requires retailers to ID for all vape and tobacco sales, exactly like the current practice for alcohol sales. With that, I stand ready for questions.
Any questions for the sponsor? Seeing none, any objection? Seeing none, we're voting to send House Bill 821 by Representative Slater on to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 821 moves on to full judiciary.
Thank you.
Members, let's go through the calendar down to item number 40, House Bill 184 by Representative Hardaway. Item number 40, House Bill 184 by Representative Hardaway. Second? Yes, sir. You're recognized.
Thank you, Mr. Chairman. This bill creates a category within reckless endangerment for community terrorism, which is criminal activity by criminal gangs.
Thank you for that explanation. Leader Lambert.
Move previous question.
Previous question is called. Any objection? Seeing none, we're voting to send House Bill 184 on to full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes, 0 nays.
The ayes prevail. House Bill 184 moves on to full judiciary.
Thank you, Mr. Chairman. Thank you, committee members.
Yes, sir. Members, will go to item 26. This will be our final bill of the day. Item 26, House Bill 555 by Representative Capley. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. Thank you, committee. House Bill 555, many of you supported last year. I want to thank you for that. We're bringing it back this year. We had a little funding issue, but anyhow, it increases from a Class E felony to a Class D felony the penalty, the offense of burglary for any freight of a passenger car, automobile, truck, trailer, boat, airplane, or other motor vehicle. Mr. Chairman, I've got several other statistics, different things here. It's being supported by stakeholders literally across the state and country. And I can answer any questions if you want me to, the committee wants me to divulge further information. So,
questions for the sponsor? Question's been called. Any objection? Seeing none, we're voting to send House Bill 555 on the full judiciary. Does anyone wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
The ayes prevail. House Bill 555 moves on to full judiciary.
thank you, Chairman. Thank you, committee.
Members, any other business before we adjourn today? Seeing none, all items left on the calendar will be rolled to next week's calendar. We are adjourned.